Hello, my name is Darlene Susa-Anderson, and I'm the Vice President of EHS Services at ChemADVISOR, and I'm happy to be with you today to discuss post-June 1st, 2015, what's left to do. So we'll first start in North America and discuss United States, Canada, and Mexico, and then we'll work our way around the globe, where we will highlight some of the remaining activities in the hazard communication form that remain to be done. So first of all, for the United States, the Hazard Communication Standard 2012 compliance deadlines are shown for you on this slide. This should be very familiar to most of the audience here. And you'll see that we've already passed these dates, and what remains is June 1st, 2016, and you'll notice in this box there's actually 3 separate activities that still remain to be completed by employers. And even though the December 1st, 2015 deadline has already passed, just want to have a few slides that explain some scenarios where the deadline has been extended. So basically, the OSHA HAZCOM 2012 requirements are that distributors shall not ship containers labeled by the manufacturer importer unless it is a GHS label. However, in the inspection procedures that were released this past summer, the summer of 2015, there was some further clarification and guidance for situations where, despite good faith efforts and diligent efforts by distributors, the distributors still do not have GHS compliant labeling. So I'm not going to read you the detail here, but you can see as you're browsing through the sentences here that the OSHA inspector is given some flexibility in identifying situations where reasonable diligence and good faith efforts have been made, and there are an extension to allow for the distributors to have GHS compliant labels past the December 1st, 2015 due date. So you can see the last few paragraphs here would explain that in more detail. And this is just a extract out of the previous slide where it just says that the OSHA inspector determines on a case-by-case basis whether or not the distributor actually indeed exhibited reasonable diligence and good faith to comply with the effective date of December 1st, 2015. And again, I bring this up post that date just so the audience is aware that there is some flexibility here. The upcoming deadline of June 1st, 2016 specifically identifies 3 activities for which work needs to be completed. The first is updating alternative workplace labeling, and I'll explain that in a bit more detail here in the next few slides. These last 2 bullets are fairly self-explanatory, so I don't have any additional material for that. But updating the written hazard communication program and providing additional employee training for anything that was newly identified as a physical or health hazard as a result of GHS implementation in the United States. So let me focus specifically on the workplace labeling requirements, and I have these first bullets in italics because this is a word-for-word extract out of the regulations. So you can see the beginning talks about exceptions found in paragraphs F7 and F8, and then it refers to containers in the workplace, and it gives you 2 scenarios that you can follow. And of course, the source of this is 29 CFR 1910.1200, Part F, Subpart 6, specifically workplace labeling. So first of all, let's just break this down, and we'll talk about paragraphs F7 and F8. And remember, these are the exceptions. So this is what paragraphs F7 and F8 actually state, that the employer can use different types of communication methods, and it gives some examples, signs, placards, etc., instead of individual labels on the individual stationary process containers, as long as the information that is there complies with the entirety of paragraph F6. There's also a special scenario in the workplace for portable containers. In other words, there are situations where a container is stored, purchased in a larger size, but then for actual use it's transferred into a smaller container, and it's intended to be used immediately by the individual who actually performs the transfer. So in that case, these are the two exemptions. So just continuing along here, also container is identified as something that's necessary to be labeled. And just as a reminder, the container definition is found in subpart C, and this is again italics, so that's exactly how it's stated in the regulations. It does say bay, barrel, etc. And more importantly, it says what is excluded from what is considered a container. So pipes and piping systems, for instance, are specifically identified as not being a container, therefore wouldn't fall into these requirements. Okay, so continuing along, it does say, notwithstanding the exceptions found in F7 and F8, containers in the workplace have to be labeled with this first bullet, anything that's specified under paragraphs F1I through 4, and what that is what we would consider a standard DHS conforming label, which contains label elements such as the name of the product and correct signal word, associated hazard statements, pictograms, and precautionary statements. So moving on to Canada. Canada's hazardous products regulations were issued in February of 2015, and we provide you the link of where the text of those regulations can actually be found. And this is a few screenshots of showing you what the beginning parts of this look like. So in the Canada Gazette, the regulations are identified for you, and as in any official government publication in Canada, it's found in English as well as Canadian French. After the regulatory text, there is something called a regulatory impact analysis statement, which says it's not part of the regulations. However, it does contain some very valuable and useful explanatory information, which we'll refer to here in another slide or two. So some key things to remember is that HPR itself was written against revision 5 of the Purple Book, but it is intended to be in alignment with the United States. And just as a reminder, and again, most audience members are fully aware of this, but HASCOM 2012 is against revision 3 of the Purple Book. So there are areas where alignment occurs, and where areas are aligned, I'm identifying for you here on this slide. The excluded building blocks, which comprise all environmental hazard classes. The added building blocks, pyrophoric gases, simple fixings, and combustible dust. However, there is a slight difference here between the handling of hazards not otherwise classified. You can see the U.S. has that acronym, and you'll notice Canada has an H and a P in front of the acronym, H standing for health and P standing for physical. So that basically subdivides hazards not otherwise classified into two distinct categories. As far as excluded health hazard categories, again, these are aligned, identical in U.S. and Canada. Acute toxicity category 5, skin corrosion irritation category 3, aspiration hazard category 2. And where there is not alignment in Canada, the biohazardous infectious materials is regulated. It was regulated under the controlled product regulations, the regulations that precede the hazardous products regulations. And also there is a requirement for appearance of both languages. Canada, Official Languages Act identifies those as Canadian, French, and English. And both languages have to appear on the safety data sheet and the label. And it could be in the form of a single document or two separate documents, but they both have to be provided. As far as further differences in alignment, there are a handful of those for carcinogenicity. So in the U.S., There's an option for labeling for mixtures for category 2 carcinogens that occur in your mixture between 0.1 and 1%, and Canada requires labeling in all cases at 0.1% or greater. Also in the United States, if you have any classifications that would fall under the HNOC, in the United States you would not have to actually have any reference to that on the label, but Canada does require associated labeling elements for these categories. And finally, in the United States, there is no special statements identified for the scenario where the product, when in contact with water, releases a gas that is acutely toxic. However, Canada does have supplemental hazard statements that have to appear, and they're identified for you in the text of the regulation. As far as the safety data sheet goes, there is alignment between the United States and Canada, where the safety data sheet itself has to be 16 sections, and the contents of sections 12 through 15 are considered optional. So you do need to have the headings, but both regulations are silent on what needs to appear in there because it's considered optional. Also alignment in the disclosure, where the names and concentration of the components classified into health hazard endpoints have to be disclosed in section 3. Also, information on the initial supplier is required in section 1. And what is no longer part of Canada's requirements is a mandatory 3-year review cycle, the ingredient disclosure list, and mandatory concentration ranges for substances which have been claimed as confidential. What has to appear on a label in Canada for a product that is classified under HPR: name of the product, initial supplier identifier, and GHS label elements. And instead of specifically identifying what those are by endpoint, it simply refers to the text of Annex 3 of the 5th revised version of the Purple Book. And just as a note, the 6th revised version of the Purple Book was published mid to late 2015. Now, however, for those endpoints that were added by Canada, not found in the Purple Book, any version, pyrophoric gases I make an exception on, there is a reference in the HPR to Schedule 5 where it actually gives you the text that is expected to appear on the label. And this is just a screenshot out of the regulations showing you, at least for these 3, what that would be. Also in Canada, unlike the United States, there is a flexibility allowance for small capacity containers, and they do divide that into 2. Containers that are less than 100 ml, containers that are even smaller, less than 3 ml. So basically gives you the scenarios for flexibility. And for the under 100 ml, you are allowed to eliminate the precautionary hazard statements, but you do need to retain the other required elements. And for even smaller containers, the allowance is that if the label interferes with the usage of the product, then that label would only need to stay available during transport and storage, but remove it during use. But if you return it to storage, if it's not a single-use container, then you do need to return the label with the rest of the label elements associated with it. Also gone from HPR is the statement on the label referencing that a safety data sheet is available. That's no longer applicable. And the hatched border itself, which used to be required to enclose the CPR required information, that's also gone as well. As far as when the content of safety data sheets have to be updated, the text of the HPR does say if significant new data is available, that you have a 90-day time frame for the safety data sheet content to be updated and a 180-day time frame for the label to be updated. Now I place this in bold because this is rather important. However, it goes on to say if you have that new information which is pending to be updated in your label and your safety data sheet, you still need to transmit that to the individual who purchases the product. So transmitted by you, the seller, to the person who acquires it, your customer. So you need to have some means in order to communicate that new information. And it may not be possible for you to update your safety data sheet and label that quickly, so there needs to be another mechanisms in place beside that to ensure that this will happen. And Canada also goes on to identify, well, what is exactly significant new data, and it is defined as anything that would result in a classification change or a change in the way users would protect themselves against the hazards presented by that product. As far as the deadlines go, they're all in our future, and the HPR text itself gives that information to you in statement form in terms of phases here. I myself like to look at it as it is found in the regulatory impact analysis statement because it provides a table. So again, it gives you the phases, and it gives you column headings to tell you who is the responsible entity: manufacturers, importers, distributors, employers. But it basically gives you what options you have. So as you can see, as you move through the years, the requirements kind of kick into place. Whereas the last deadline on the table is December 1st, 2018, but note that there's a footnote. And in the footnote, it talks about some additional time that you might have depending on your specific scenario for things that are already labeled for CPR compliance and already in the workplace. Now, you need to be aware that HPR exists at the national level, but at the provincial and territorial level, there's also additional regulations that exist. And most importantly, they establish occupational exposure limits and training requirements. And this is a work in progress. So the best thing I can tell you is that if you haven't been there already, there is a website that's dedicated to this information, the National WHMIS portal. And if you go to the website, this is a screenshot of what the home page would look like. And if you scroll down, you would see a map of Canada showing the various provinces and territories. And you can actually click on the map or click on these little tabs that are below it. And if you went through and looked specifically at a certain jurisdiction, you would find that. And this just gives you in a written slide what the names are of all the territories and provinces. And this is what it would look like if you selected Ontario. So you can see what would happen is it gives you a summary of responsible party, and it gives you the status of WHMIS and other relevant information as well. So depending on if you have a facility in Canada, distribution center, manufacturing site, or some very important customers, you may want to pay attention to this provincial territorial specifics. And just as a highlight summary, each province and territory have made a commitment to move forward. And in some cases, some have moved forward much quicker than others. So again, the most timely information I can give you is to go to the WHMIS.org website and take a look at the status for any jurisdiction that you're interested in. Continuing in North America, move down to Mexico. And the most recent thing that happened was in October of 2015, where the Secretary of Labor and Social Welfare released an update to NOM 18, and that is titled the System for the Identification and Communication of Hazards and Risks for Hazardous Chemicals in the Workplace. And there was a 3-year time frame associated with that. So basically we are still in that transition period. If you want the text, you can actually go to this website. It is in Spanish, or you can purchase an English version through this website, or there's others out there. We have no relationship with this organization, but just providing you this as information purposes only. So if you actually looked at the content of the revised NOM, you would see it has 16 parts and several appendices. So I'm just going to highlight a few things that are of relevance. The first thing is that it applies in the workplace, and it's where hazardous chemicals are handled, transported, or stored. And these bullets give you the scenarios for which this revised NOM does not apply. And again, I'm not going to read that to you, but you can kind of see this. And the reason these are identified is because these requirements are handled by another regulation in Mexico. So what is required is, as an employer, training. And these first and the fourth bullets kind of go together. Training with records. Maintaining safety data sheets for any incoming raw materials, and also providing compliant safety data sheets for any product produced in the workplace that are appropriately labeled. As far as, well, what is exactly considered hazardous? It refers to the Purple Book, and what is excluded are all environmental hazards. So that's hazardous to the aquatic environment, acute and chronic, as well as hazardous to the ozone layer. And then, of course, covered is physical and health hazards. Appendix E of the standard gives you information on the safety data sheet. Obviously, it has to be made available in Spanish using a 16-section format, and some basic requirements. Correct content, no blank spaces, and updated in the event that there's new information. Appendix E goes on beyond providing the simple format, but it does give you more extensive guidance. So in general, you also do need to include the page number of total on each page, the name of the product on each page, and the SI, or standard international units, as far as physical properties that have actually units of measure. So Celsius instead of Fahrenheit is a simple example of that. There's also a section-by-section guide, and of course it's going to be in Spanish, which gives you more detail of what is expected to be included in each section. Also available within this guide is a reference to other personal protective equipment symbols that may be considered. And this just gives you, and this is directly out of the Purple Book, examples from European Union Directive on PPE in the workplace, and examples from the South African requirements for workplace labeling. And this also shows you personal protective equipment symbols very similar to what was provided in the previous version of NOM 18, and based upon the American Coatings Association system, HMIS. Also in this guidance document is an interview questionnaire. So basically identifying questions regarding compliance that may be of use to you as well. As far as the European Union goes, we've essentially passed the major deadlines identified in the European Union CLP regulation. However, there was a 7th ATP published in July of 2015 with changes to Annex 6, and the Annex 6 entry changes shall be mandatorily applied no later than January 1st, 2017. I don't have a slide on this, but the 8th ATP as well as the 9th ATP are in draft, and the expectation is that sometime in 2016 or later those would publish. And of particular note for the 9th ATP is the intention to delete Annex 6 Part 3.2, which simply is the former R and S phrases and symbols associated with that from the DSD, DPD, Dangerous Substance Directive, and Dangerous Preparations Directive. And also wanted to share with you countries other than those we just discussed. And these are simply kind of in order by date. So you can see that there's additional requirements. And again, I realize that this date is already passed, but for Taiwan to have compliant products for any product that meets the criteria as specified in the CNS 15030 standards. For Singapore, mid-2016, for users of general mixtures to comply with requirements under the Singapore Standards 586 series. End of the year for Japan for any provisions that are found in their standard, JISZ 7253. Australia's Workplace Health and Safety Regulations, January 1st, 2017. Thailand, substance deadline has already passed. The mixture deadline is in the future. Likewise with Uruguay. And of course, we've already mentioned Mexico is coming up in 2018. So as you can see, by the last 20 minutes or so, there are a lot of requirements to be complied with yet. Not only in the United States and our neighbors to the north and south in Canada and Mexico, but as we move our way around the globe, there's still requirements for GHS conforming products that need to be met. So what can you do to get into compliance? Well, the first thing is to get educated, and attending this presentation is a good first step. We also, as a company, host specific training classes on very country-specific requirements, and you can go to our website, www.ChemADVISOR.com, to see the specifics as far as that goes. And if there's a class that you're specifically interested in that isn't listed, we also do custom courses, and we also do on-site training as well too. So just get educated, and that's a good first thought for any compliance strategy. Also, identify what products you're actually manufacturing in a specific country or selling into a specific country for countries whose deadlines have not completely passed yet. Then, once you armed with knowledge and a list of products, then develop a compliance plan. And certainly working with ChemADVISOR senior consultants to develop that plan is a way to go about it. Then, once you've identified what needs to be done and when it needs to be done and how you're going to do it, I'm certain that compliance safety data sheets and labels are going to be part of that plan, and either that's something that you learn how to do yourself by attending a training class, or we can do that for you. And as far as training goes, not only train you as the compliance professional that is responsible, but also if you need to train your employees, we can help with that too as well. And in closing, I just want to refer you to our ChemADVISOR blog. We do publish as new requirements become available that are relevant to our audience, specifically in regards to hazard communication or other regulatory requirements. So we're continually monitoring regulations around the globe and ensuring that that content is made available in the appropriate avenues, including our regulatory database, our training modules, and as we work through any consulting services. So thank you for your attention.